legislation is straightforward and common sense bill. I think it will apply the code of conduct for the United States judges to the 9 judges of the Supreme Court. Now, the goal of the code of conduct for the United States judges is simple. It protects the public confidence in the federal judiciary. Shockingly, the code of conduct applies to all federal judges except those on the United States Supreme Court, our nation's most important legal institution. I'm not new to this issue, and over the past few years, and with the help of Alliance for Justice and Common Cause and more than 210 law professors in the country, I've been investigating some cases of impropriety on the court. At least to me, it seems to be improper. And discovered that members of the Supreme Court have engaged in egregious behavior that we believe does not conform with the ethical standards laid out in the code. Most notably, Justice Clarence Thomas failed to correctly disclose income received by his wife while she was working for the Heritage Foundation, which has repeatedly advocated on issues before the court and a committed attempt to overturn the Affordable Care Act. More disconcerting than that was that Justice Thomas correctly filled out the disclosure forms for 10 years and then stopped. Specifically, we learned that he had disclosed his wife's income, and then he began to write the word none to declare that his wife was not receiving income. And while he wrote the words none on the disclosure form, his wife was earning at least $1.6 million in income. We considered that an act of will, although Chief Justice, I must tell you, did not. He thought it was an oversight. Justice Thomas himself said he did not understand the form. Since a willful failure to disclose such income would be a violation of the Ethics in Government Act of 1978, I wrote 2 letters, joined by dozens of my colleagues in the House, to the U.S. Judicial Conference, requesting that the matter be looked into. And after months of waiting for a response, the Judicial Conference sent me a little brief letter telling me they found no evidence at all that this was done willfully. But it does remain hard for me to understand how he could have misunderstood the simple disclosure form, since he had filled them out 10 years before correctly. But this bill is not about one justice. In addition to Justice Thomas' suspicious failure to disclose income, Justice Alito and Scalia have been involved in behavior that would seem to violate the code of conduct. In 2008, Justice Alito headlined the American Spectator magazine's annual fundraising gala and attended the event again in 2010. He also headlined a fundraiser for the Conservative Intercollegiate Studies Initiative of 2009. This organization declares that they work to realize limited government, individual liberty, personal responsibility, the rule of law, market economy, and moral norms. And finally, in 2011, Justice Scalia attended an overtly political gathering of conservative activists, including Charles and David Polk. The 2011 invitation of the event explicitly stated that he would be there, and its purpose was to plan how to, quote, change the balance of power in Congress, end quote. In his year-end report on the state of the federal judiciary, Justice Roberts declared the court had no reason to adopt a code of conduct as a definitive source of ethical guidance, that they had a copy of it nearby that they could look at. Yet if the code of conduct applied to the Supreme Court, much, if not all, of what we believe are questionable behavior would have been taken place. Because the code sets forth very simple rules, such as no political activity. We think that's very important. No fundraising, and the necessity to avoid even the appearance of impropriety. And that's why it's so important, I think, that we apply a binding code of conduct to the members of the highest court in the land. The guidelines contained in the code exist to ensure that the public has faith that judicial decision-making is based solely on the facts and the law, not politics and outside interests. Recently, my favorite judge in Western New York, Judge Teleska, a good federal judge, a Reagan appointee, who sleeps with a copy of the Constitution under his pillow, told me that he thought this was a very good idea, since almost all judges on the Supreme Court had been federal judges. They were quite accustomed to the code and had always been able to live under it quite well. Accordingly, adoption of the similar code of conduct from the federal judges to the Supreme Court should not unduly burden them. And it certainly would serve as an impediment for their complete and robust service on the court. Now, I've been focused on cleaning up Washington for years. As Pat Schroeder said, I've been working myself to death and it's still dirty. In 2006, I authored a report called America for Sale that exposed widespread corruption and unethical behavior in Congress. Last year, I passed the Stock Act, which bans insider trading in Congress. And I believe that every public official, no matter what their position or power may be, must be held accountable to the highest of ethical standards. There is no reason why the Supreme Court should be exempt from the Code of Conduct for U.S. judges. And I look forward to working with my colleagues in the Senate to apply the code to the Supreme Court and to provide accountability and transparency to the American people.